For judgment, item number 1, WPC 11525 of 2008. Said that the penalty amount must be returned within a period of 4 weeks. There's a delay, it will carry just simply into the process. For judgment, item number 2, STRAV 21 of 2008. The issued orders of the tribunal are set aside. Corresponding orders of the ACST are restored to file. The revision petitions are disclosed. We've answered the questions in favor of yes. Next.
human consumption. Is it calorie based or what?
It's based on calories, sir.
But then there are complaints received number of times. The quantity is very less.
So there are two basic issues for which we got the matter listed today. So one is a letter. I don't know if you have a copy of that letter, sir.
No,
From this organization called Madhyam.
that letter copy is
So
not.
they have pointed out that there are some women's jails. They've given us a list of those jails. Where is that? Scan.
At flag 56, it is there.
There are some women's jails where there is only one inmate, sir.
Yes, sir.
So they
They
are
need to be
concerned
shifted
about the
to
mental
district.
health of such inmates, because if they're going to be isolated, it's like isolation ward. So they are suggesting, sir, shifting such single women inmate to the nearest jail where it could be another woman inmate.
Yes,
This is
sir.
their
We have already, sir, instructed to the sub jails having one inmate to shift to district jail, sir.
So how early can you do this, sir?
The review is being done and we are transferring, sir. Process has been started, sir.
No, Mr. Mishra, what is your suggestion? One is I was suggesting,
My lord.
subject to what you might say.
No, whatever your lordship will suggest, we'll carry out.
No, we are prepared to sit on a Saturday. Not even asked you, but
My lord, what I would suggest
so
is,
we'll use technology.
my lord,
Let them give us actual physical inspections of on real-time basis
my lord,
of the conditions of the jails, the toilets. We'll do jail by jail.
my lord.
We're prepared to do it. So on a Saturday, in the first half, we'll do a set of jails. In the second half, we'll do a set of jails. We can't cover obviously all the 87 jails,
My lord.
but let us make some progress.
My lord.
Something has to be done, sir, because this is going with
Regarding-
all our attention. If this is happening, then
Yes.
I'm wondering what is this?
Actually, regarding food also, I am told by many of these unofficially that they give it at about 6 p.m. in the evening, 6, 7. So the next meal is almost 13, 14.
More than 14 hours away.
Yes. So that's also an issue in some jails. Since because of overcrowding, we have actually, I am also to blame. The other issues have been neglected. So what falls?
These
to
are
the
very
lordship is
basic
correct.
issues. So we just can't afford compromises on these things. The condition of the wards, I don't know how they are, because many of these jails are very old, sir. Correct, Mr.
Yes,
Paul?
sir.
So we have to say, you take advantage of a high court being involved. You better get whoever the PWD, whoever is doing those civil works. If you have to repair the toilets, do it. You have to clean them up, do it. If there are broken doors, broken toilets, I'm sure this is problem everywhere. Lack of water. You have to set these things right, sir. Let us do it jail by jail. Now you tell us which jails you want to show us on the next sitting.
Yes.
You give us, we'll definitely want to see the Koraput sub jail. That's definitely there. But which other jail? In and around Koraput, can we see the Malkangiri jail?
Yes, madam.
Malkangiri, Nabrangpur, these are all. In
So
and
let us focus, start with the southern jails.
My lord.
Can we do that, sir?
Yes, sir.
So what I hope you understand what I'm trying to say, that there will be a live, real-time tour that you take us of the jail. All right.
Yes, sir.
You can even do it on a mobile camera. You don't have to have a sophisticated camera and all that. It's like a regular jail inspection.
At present, sir, the raised DIG presents are visiting the jail surprisingly, sir. Senior superintendents of jails are also visiting surprisingly.
No, so we can ask, if you so suggest, we can ask the non-official visitors and visitors to undertake immediate visits right away.
Yes.
Lord,
Yes, sir.
in fact, Lord, the DLS secretary may also be requested. To,
Yeah, the concerned DLS secretary.
DLSA secretary can be assigned with this job. That will be better because
Alright.
he's a judicial man.
Right.
But what your lordship
At
is
least with
suggest-
1 or 2 non-official visitors come
Yes.
with the DLSA secretary, let them take spot visits,
yes,
unannounced spot visits.
My lord. All non-official visitors, my lord, may say, because those are actually these engineers and all. If they visit, they'll come to know what is required,
All right,
and they can on their own
My lord,
rectify without waiting for court orders.
right.
They should start rectifying these
Alright.
small issues.
One thing is there, by this process, some other persons may enter into the premises. Some authorized persons should be directed.
No,
to
only the
visit. Yes.
assigned non-official
Yes,
visitors.
assigned. The person
yeah.
should be duly assigned with the job of inspection.
That's right.
Then only we will allow, superintendent will allow.
All right. You say there were two purposes for which today's the matter has been taken up today. One is on the basis of one purpose is to deal with the problem of single some of the jails, of some of the women's jails having a single inmate in the entire jail. Full stop. A letter has been sent to the court by the organization, by the non-governmental organization, Madhyam, by its letter dated 1st April 2022, which is working on the project single quotes Kiran, which provides rehabilitation to under trial prisoners in various jails of Odisha in collaboration with the DG Prisons and Correctional Services. Full stop. They are concerned about the mental health of the single woman inmates in as many as 8 sub-jails in Orissa. In 11 sub-jails, there are 2 or less female under trial prisoners. Full stop. The suggestion is that they should be moved to the nearest sub-jail which has female inmate population. Stop. A copy of this letter has been made available to learned additional government advocate who will share it with the DG Prisons right away. Full stop. Mr. Sanjay Kumar Paul.
Subhakant Mishra.
Subhakant Mishra.
Oh, that name is.
Yes, my lord.
Mr. Subhakant Mishra, the DIG Prisons.
Yes, DIG Prisons.
Is present in virtual mode and states that instructions have already been issued to the concerned sub-jails to shift the single inmates to the nearest jails / sub-jails, so that where there are other women inmates. Full stop. A compliance report in this regard be placed before the court positively within 1 week. That is on or before 18th April 2022. Paragraph. The second issue that the court is deeply concerned about arises from a surprise visit undertaken by one of our colleagues, Justice S.K. Panagrihi, to the Koraput sub-jail when he was visiting that district as the administrative judge in charge. Stop. He has reported how the condition of the toilets in the Koraput sub-jail was appalling. They were plainly unusable and an utterly filthy condition. Stop. He has also drawn the attention of the court to the fact that the food served in Koraput sub-jail was simply inedible. In other words, it was of such poor quality that it was not fit for human consumption at all. Stop. The court expressed its deepest concern on these issues and hereby issues a directive to the Directorate General of Prisons to ensure that there is not a single jail, sub-jail in Orissa where the toilets are not clean, the prison wards are not hygienic, and the food quality is not of the best possible standard, given the budget allocated for prisoners, both under trials and convicts. Full stop. The court would like to emphasize it's not only about the quality of the food, but also the quantity in terms of calorific value, which has to be ensured. Paragraph. The court directs that every secretary of every district legal services authority will undertake an unannounced visit along with the non-official visitors of the concerned jail to the jails and sub-jails within the jurisdiction of the concerned district in the next 1 week, and specifically inspect the condition of the toilets, the cleanliness of the wards, and the quality and quantity of food being served to the inmates. They will also immediately report on the available medical facilities, both for physical well-being as well as mental well-being of the prisoners. Stop. The court would like, wherever possible, the inspecting team to have photographs taken on mobile phones, photographs or videos taken on mobile phones, and submit these as a report in soft copy through the member secretary, Orissa State Legal Services Authority (OSLA). Copies thereof be emailed directly to the learned amicus curiae, Mr. Gautam Mishra, who will then analyze them and place his submissions before the court on the next date. We'll take it up on 18th April, sir. List on 18th April at 10:30 a.m.
The
Is there
letter,
anything else on 18th?
18th April. 18th April.
Contract will start. 19th April also, sir. 20th April, there is nothing. 20th April, sir. 20th April at 10:30 a.m.
the letter dated 1/4 of Madhyam, that may be shared with the member, maybe provided to the member secretary as well as myself, so that we can
add that,
follow it up.
Shared with the member secretary, OSLA. A copy of this order be sent to the member secretary OSLA, who will in turn hold a virtual meeting with all the secretaries of the DLSs not later than tomorrow morning at 10:30 a.m. to instruct them about strict compliance with the above directions.
And the letter of Madhyam, that letter, those female prisoners, I think some steps can be taken to get them released. Normally, ladies are allowed to be released. So that letter can be shared so that we can take follow-up action parallel.
Get the details.
Right.
My lord, this order may be communicated to the DG.
The order, copy of the order also be sent to the DG prisons, both by email and through special messenger, forthwith. Thank you, Mr. Mahapatra, right?
Mr. Mishra.
Mr. Mishra. Sorry. Thank you, Mr. Mishra. Thank you.
We agree.
My
I think
lord,
she's standing
I may kindly be allowed to access the judgment.
Sorry?
I may kindly be allowed to access the judgment.
Actually, this is in between. You should have done it in the mentioning time. This is the first item that is over. Anyway, tell us.
I just wanted to know the judgment outcome.
So we have asked them to email it to you also.
No.
If you wait here, we'll make a copy available to you right away.
Okay, my lord.
Just wait in the court.
Take your place.
Just tell them to make a photocopy and give it to you. And kindly do not interrupt the court proceedings. Whatever you feel about the judgment, you are a senior, you've been a lawyer, you've been a judicial officer. You have to follow the etiquette of the court. All right.
Special weekly list. Old matter item number 3.
Item 3, made lordship. I'm on BC lordship. Item number 3, lordship. I don't have instruction lordship. Lordship may give liberty and dispatch of the application. Item 3, lordship. I am on BC lordship.
Yes, please.
Lordship, no instruction lordship.
All right.
And liberty may be given to approach.
No liberty. Right. These are all very old matters.
Old matter item number 4.
Item 4, my lordship. Item 4, my lordship, it has been infructuous, my lordship.
All right. Counsel petitioner states petition has been rendered disposed of as such.
Item number 5.
Instruction so that does he know? You first.
Special liquid list, whole matter item number 5. Item number 5.
None appears dismissed. No prosecution.
Special liquid list item number 6.
Your Lordship, item number 6, Your Lordship, file is not available. File is not available.
Counsel for the state says file is not available. Dismissed non-prosecution. With the liberty to revive the petition as and when the file is able to be located.
Special liquid list item number 7.
So may I please, my lords?
Yes.
So in this case, earlier copy has already been served, and yesterday also one more copy I have given to a learned friend. So I think my friend may not have any objection to this. Because page 13, I have formulated 4 questions. Because out of 4 questions, question number B has already been covered by your lordship judgment in Gupta distributor's case. Because if B is answered by your lordship, probably all other questions need not be answered by us, even though others are also substantial. But question number B, my lords, may kindly see for a moment at page 13, whether in the facts and circumstances of the case, enhancement of turnover in absence of any material to establish that the goods found short have been sold is lawful and valid as per the ratio decided in the case of Mahabir Rice Mill versus State of Orissa, etc. Because this question number B, whereas Mahabir Rice Mills have also been followed by your lordship, but I am giving a copy of judgment to your lordship in the court. I have your lordship may kindly see the judgment of Gupta distributor. Gupta distributor. Gupta distributor judgment, paragraph 7 and 8 are relevant laws. The main charge against the assessee was regarding unexplained shortage of stocks, as explained by this court in Lakshmi Narayan Savalram versus State of Orissa, order date so and so, OG so and so, unless the department is further able to show that the suppressed stocks were sold by the assessee, there cannot be an automatic enhancement of the taxable turnover. Para 8 minus. May I proceed, Manus?
Sorry, yes, sir. Carry on.
That's paragraph 7 minus of Gupta distributors judgment, STREV 02 of 2008 minus. Paragraph 7, internal page 3. The main charge.
Yes.
The main charge against the assessee was regarding unexplained shortage of stocks, as explained by this court in Lakshmi Narayan Savalram versus State of Orissa, order dated 20th July 71 OGC number so and so, unless the department is further able to show that the suppressed stocks were sold by the assessee, there cannot be an automatic enhancement of the taxable turnover. Paragraph B minus. For the aforementioned reasons, the court is unable to sustain the reasoning of the tribunal for restoring the order of the STO and reversing the order of the SCST. The question framed by this court is answered in the negative by holding that the enhancement of turnover in the absence of any material to establish that the goods found short have been sold is neither lawful nor valid and is contrary to a law explained by the court in Mahabir Rice Mills, Supra. The question is accordingly answered in favor of the assessee and against the department. Yes, in this case, what has been happened, Millars? The petitioner, Millars, there are 2 reports submitted by 2 different wings, Millars. And both of the department, Millars, this vigilance and internal report of the department, they have at least shortage of stock. One stock of shortage on account of trials that was accepted, Minos. That was because that was in accordance with the letter of the government that this much of percentage allowed, that is accepted by as per the government letter. And but tribunal or even though accepted, page 25 will also be kindly for the moment. Page 25, the first appeal authority, after examining the case in detail, it starts from page 24.
Yes.
Let me place from page 25 regarding the shortage. You will also kindly see the second line. Yes, regarding the shortage of stock of paddy, the argument of the learned advocate is considered genuine as the shortage were found to be within the permissible limit of shortage as allowed by the government in Civil Supply Department, CS Department, Civil Supply. The shortage in stock of paddy, rice, broken rice is bound to be occurred in course of shortage and handling, storage and handling. The excess stock as reported by the ISTM circle is seemed to have been calculated on I estimation, taking each bag of paddy at uniform rate of 75 kg each, but without women taking off all the stock of paddy at uniform rate denies natural justice, especially without the same being confronted with the appellant. The vigilance wing previously had taken the stock on sample women, that is at the rate of 64 kg per bag. When the stock is taken, at the rate of 64 kg per bag, and the admissible shortage into account, the physical stock of the appellant remains at a level approximately equal with the book balance. Hence, in absence of concrete evidence of excess stock of paddy being proved by the circumstances as well as books of accounts, the purchase suppression of paddy leveled against the appellant doesn't stand. Therefore, the allegations made against the appellant for self-suppression based on detection of shortages or excess of stock of paddy rice and broken rice is considered unfounded. The enhancement made on this score is a return turnover. Return turnover of the appellant is therefore waived, and the extra tax demand raised on this account number 2,51,744 is deleted. Yes, this finding of the SCST when challenged for tribunal, the learned tribunal has reversed and enhanced the assessment. That your lordship will find, Millards, the enhancement portion, page 41. In page 41. In view of the discussions in the foregoing paragraphs, the appeal filed by the state is partly allowed, and the first appeal order SCST is enhanced by rupees 2,46,937, and the assessment of the order is reduced by 4,811.
Enhancement was made to the appeal order, appellate authority, not assessment.
But one more question which I have framed, Millers, and that is answered, copy of which I have given to the lordship in the case of Millers. Utkal Self Corporation, there is a specific rule 53 Millers, 50 sub rule 3, that says that tribunal cannot enhance unless a notice before enhancement is issued to the appellant giving opportunity. That your lordship has said in many cases. So I am not going to that, because if your lordship will consider question number B in my favor, probably all other questions did not be answered. But I keep reserve that question. If I learn present, then I will also use. Because now, so far reasoning part is concerned, what the tribunal has said, my lords may kindly see, lords, that your lordship will find from page 41. Sorry, 39. I'm so sorry, 39. Page 39. At the top, subpara 2 lords. Shortage of 18.55 quintals of paddy, 0.51 rice as found on 6/6/97 were explained by the respondent as shortages on account of dries and within the permissible limit prescribed by the State Civil Supply Department of Orissa. This stand of the respondent accepted, and therefore the respondent is exonerated from charge of indulging self-suppression of discourse, but shortages of 4.88 quintals of rice and 1 quintal broken rice are not accepted as shortages on account of dries, because shortages to the tune are not practically possible within a period of 11 days. So these shortages are unequally concluded as out of account sales. Similarly, excess stock of 1899.15 quintals paddy has already been concluded as out of account purchases, discarding the plea of estimation of stock on sampling method, that is each bag cannot uniformly contain 75 kg of paddy. Now, what has happened, Millers? Because the vigilance, while Millers submitting report, has estimated, Millers, even though the contention was bags do not contain similar quantity, and Millers, they have adopted a tape measuring method which is deprecated by a judgment of this Honorable, which I have referred to, they have not considered. That my lords will find page 35 for a moment, my lords, with kindness. Because measurement cannot be done on best estimation. Your Lordship may carry page 35, whereas 245. I am placing whereas page paragraph 8, last 4 lines. 245. My Lordship, that is point. 245 is stand. Sri Dani has placed reliance in the decision of Honorable High Court of Orissa in the case of Hari Bhagat Agarwala, which is State of Orissa, 51 ST 355, and has quoted the following few lines from the aforesaid judgment. On reference to the records, we find that the measurement was made by the revenue officials by using a tape, which means that the entire things are verified not physically but by sampling method, which has been done in this case. A sampling method of verification may be useful for certain purpose, but cannot be utilized on the basis for imposition of tax. This judgment, which completely fits it, though referred to by the tribunal, no finding on the judgment of this honorable court whether the judgment is correct or not, whether the sampling method which is adopted by the officer based on measuring on tape without physical movement of all, because rice mill, huge tons of loads of rice bags are there. It cannot be physically, it can be, but it will take time. But by tape measurement, going by tape measurement, one cannot find out certain. Therefore, your Lordship said, even if you arrive at on any ground shortage, you must have some material to establish that the goods found shortage are sold. Otherwise, no tax can be levied. And Miller's regarding enhancement of turnover made by the Miller's tribunal, Rule 53 at this stage, I could have pressed that Miller's, because supposing your Lordship will set aside and direct the tribunal, this matter pertains to 97-98. After 22 years, if the matters will go back to tribunal, perhaps neither revenue nor me can be able to produce accounts, documents to again go back and redecide the matter. So therefore, if on the basis of my judgment, and the judgment referred to by our High Court in 51 STC, this clause, question number B is answered, I think matter can be reasonably.
Your Lordship, may I please, Your Lordship? Your Lordship, so far as the enhancement, Your Lordship, that enhancement rule 50, no, sub rule 3 may not be applicable. Why, Your Lordship? There was assessment has been made. In the assessment, demand has been raised. Subsequently, first appeal has been filed by the dealer, by the assessee. And first appeal has been partly allowed. Some portion has been allowed in the first appeal by the first appellate authority. Against that allowance, department has filed to second appeal. And before second appellate authority, before tribunal, the petitioner, the dealer, as well as the state, both have appeared. And at the time of hearing, it has been considered, and the order passed by the first appellate authority has been enhanced. So, Your Lordship, there may not be any necessity of Rule 50, so cause notice again for enhancement. So, all these are to be applied, Your Lordship, because the state appeal has been allowed by the tribunal. And Your Lordship may kindly turn to page 41, the finding of the tribunal. In view of the discussions in the foregoing paragraphs, the appeal filed by the state is partly allowed. And the first appeal order of the law and SCST is enhanced. Enhanced means, Your Lordship may kindly turn to the first appeal order. First appellate authority, what has been allowed, that has been enhanced. And the assessment order, the demand has been reduced. First appeal is enhanced by 2,46,937. The assessment order of the law and STO is reduced by 4,811. So there is no question of enhancement, Your Lordship, so far as the assessment is concerned, because assessment has been confirmed by the law and tribunal. Not only confirmed, reduced. Now, Your Lordship, so far as the stock is concerned, Your Lordship may kindly turn to page 30. Not only there is stock discrepancy, there is also purchase discrepancy as well as sale discrepancy, Your Lordship. Your Lordship, page 30, as evident from the aforesaid figure, there were excess stock of 1,899 quintals of paddy and shortage of so and so quintal rice, 1 quintal of broco. The director of the company could not offer any satisfactory explanation about the discrepancy. Consequently, the inspecting officer had submitted short case report inculpating the respondent's indulgence in purchase operation of 1,899 quintals of paddy and sales operation of 1 quintal of broken rice. Now, Your Lordship may kindly turn to the next page 31. as it transpired from the assessment order on the date of visit, the director of the company himself stated categorically that each bag of paddy contains 75 kg and inspecting officer has allowed the respondent to make entry whatever purchases and sales effected by the time of visit, and in the process, respondents purchase of 1,000 bags of paddy, which is alleged not to have taken into account, had actually been taken into account. Resultantly, the sales tax officer established purchase operation of so and so quintal of paddy and sales operation of so and so and 1 quintal of broken rice, Your Lordship. Your Lordship, just before calculation, the quantity of rice was estimated at out of account, just 4 lines below. Sale of rice of its value was estimated at 9 lakh so and so at the rate 687.24 quintals as disclosed by the dealer. Your Lordship, now only 10% of the GTO, Your Lordship, the Lawn and STO estimated the total sales operation indulged in by the respondent for the year 97-98 at rupees so and so, which is 10% of the GTO and 7 times of this operation on us. Now, Your Lordship, all these facts are concerned, and Your Lordship may kindly turn to the finding of the tribunal. Your Lordship, at page 37, it starts from page 37, paragraph 9.a. And the tribunal, after touching every point, has confirmed the order of assessment, Your Lordship. And not only confirmed, reduced the order of assessment by rupees 4,811, Your Lordship. So the Law and Tribunal, being the fact-finding authority, has determined the facts entirely for that has been started from paragraph 9.8 and, Your Lordship, till paragraph 40, page 41, Your Lordship. Therefore, this judgment in Gupta in Gupta distributor may not be applicable so far as purchase suppression and sales suppression, and there is that may not be applicable.
All right.
Because so far as 50 sub-rule 3 is concerned, plus after first appeal order is passed, plus order of assessment merges by virtue of doctrine of merger with that of the order passed by the SCST laws. Because Your Lordship, the first judgment which I have given in the compilation laws, that is in the case of Mutual Sales Corporation, because against the order passed by the Assistant Commissioner Sales Tax, whereas the tribunal made an enhancement. Your Lordship, kindly see order that STRGB 245 of 2007, order dated 12/3/2008. Your Lordship will find the writ petition has been filed. Initially, writ petition filed, then I was permitted for STRGB. The operative posted order in view of the discussion in the foregoing paragraph, second appeal filed by the state sections and that of the judge dismissed. Accordingly, appeal order of the land ST is passed. The land STO shall issue demand notice for extra demand raised under 81. Then the grievance of the petition that said
actual assessment. No, but Mr. Sahu, here what's happened is the order of the STOs, the demand raised for the order of assessment has in fact been reduced by 4,000 odd rupees.
Yes.
It's not been enhanced.
No, not. Your Lordship will come to know only after looking at the SCST order at page 25 minutes.
No.
Your Lordship will reconcile.
The matter is still fluid. You see, if the matter stops at the SCST, what you say is right. If the matter is traveled up to the tribunal, then we have to see the overall effect of what happens in the tribunal. If the overall effect is that actually the demand is reduced by 4,000 odd rupees, you can't say it's an enhancement.
No. My Lordship, kindly see page 22 so that it can be clearer.
Yeah, ACST reduced, you're right.
Because that, yes, page 22, Your Lordship, kindly see. Demand raised is, Your Lordship rightly said, my Lordship, kindly see. Page 22, the demand raised is 3,41,352.
Correct.
There is no multiple assessment, single assessment, 3,41,000. Now the effect of assessment, my Lordship,
if you logically take this merger doctrine,
right?
Then even the ACST order now gets merged with the tribunal's order.
Correct.
So if you see the overall merger, the net effect is that you've gained by 4,000 odd rupees.
Net effect, my Lordship. Yes, net effect, Your Lordship will find.
3,41,000 was the demand by the STO.
Now it's 2 lakh something. Yeah.
3,36,000
Correct.
at the tribunal.
No. SCST demand is enhanced by 246 assessment order because there cannot be 2 assessments. There is only 1 assessment. Genesis of assessment is only 1. There are not more than 1.
Correct.
STO, Law and STO is reduced by 4 means what? STO has assessed me 3,26,000. So it is reduced by 4 lakhs means 4,000 means it is 3,22,000. Millards, assessment demand is 3,26,000 and assessment made by STO is reduced by 4,811. So it is 3,22,000.
Correct.
So therefore, and net effect is when the assistant commissioner determined the tax reduced by 2,51,000. You have to make page 25. That means 3,26,000 minus 2,51,000. That is the net status of the demand, Millards. Now the status of demand after tribunal's disposal is Millards 3,26,000 minus 4,811. Means 3,22,000 somewhat. It is more than what the first tribunal has determined. It is always more. So therefore, that has also been taken care of. Rule 53, if your lordship will say, notice is mandatory. But even if your lordship will decide the question on merit, Millards,
Your Lordship, one small point, I may draw your Lordship's attention at page 34. In spite of due service of notice under Rule 57 of the OST rule, the respondent
I am not on that question. I am not pressing. So that question is not. I am not pressing that. No, I am not on that.
So
I am now only.
Mr. Sahu will only consider question B.
Yes.
You win or lose by question B. All right.
Yeah, absolutely correct. Absolutely. Yes.
You have done, we'll reserve orders. We'll reserve orders. All right. Orders reserved. All right.
Special weekly list item number 8.
May I please, ma'am?
Appeal effect is 50,000.
Only one point is double taxation. I'm pressing the question number IB, Roman IB. They have collected that selling dealer already collected and deposited, and again they are demanding on same tax on the assessee. Only on that point, 25,000, and the next 4 is the evidence. And
So for 25,000, you want to press this. 25,000 is nothing, sir. The tax amount being insignificant, the court does not consider appropriate to entertain the present revision petition. The question of law urged is left open for consideration in some other appropriate case. The revision petition is disposed of.
Special weekly list item number 9.
None appears dismissed in opposition.
Special weekly item number 10.
Your Lordship, item number 10, Your Lordship. Your Lordship may kindly turn to the question of law at page 13, Your Lordship.
No, has the other side been served?
Your Lordship, already question of law has been framed, delay has been condoned, Your Lordship.
All right, let's see the question of law.
Whether in the facts and circumstances of the case, Lawrence Sales Tax Tribunal is correct in law in coming to the conclusion that the movement of the goods transported from the outside the state is to the site of execution of works by the contractor is the result of sale of incident of a contract of sale, when in fact the effect of the movement of the goods is neither the result of a sale nor incident or contract of sale. A concludent slashes. So in all these questions are whether it is an interstate sale or intrastate sale. Now your Lordship may kindly turn to the operative portion of the tribunal's order. Your Lordship, at page 38, running page 38 and page 7, internal page 7, paragraph 5.a.
Yes.
Having considered the respective contention of the parties in the light of the materials available on record, and the reasons which weighed with the learned assessing officer and learned SCST, keeping in view the terms and conditions of the contract regarding mode of payment, taxes, duties, and mode of dispatch, insurance, performance guarantee, we have no hesitation to hold that the impugned transaction come within the purview of interstate sale under section 33A of the CST Act not outside the tax, not under the state act or rules as per the pre-existing contract. There was the movement of goods from the place outside Orissa to work site in Orissa on the strength of declaration in Form C, and the goods were dispatched in which the assessee is the consigner and the contractee in the consignee, and the contractee used his own goods in execution of was contract to the assessee had effected and commissioned equipment for material handling system of the contractee. No doubt the contract is indivisible works contract which is made divisible by virtue of 46th Amendment of the Constitution. Even though the contract was executed inside Orissa, the taxable event so far as the execution of was contract is concerned took place inside the state of Orissa when the goods were used in execution of works contract, yet the total material were brought out from the outside the state by the contractee for the contractor used by the contractee itself for execution of works contract through the assessee. The turnover of such interstate sale is beyond the scope of the assessment under the State Act, and the rules has to be excluded while determining the TTO as has been determined Supreme Court. Now, Your Lordship, the Law and Tribunal has stated that it is an interstate purchase. Now, Your Lordship, my humble submission before Your Lordship is that the dealer assessor is responsible not only for supply of goods, but also use them to bring the contracted goods material handling charges, and there is no denial by the revenue that it involves the goods involved in execution of was contract have been brought outside of the state of Orissa, but the said goods those brought from outside of the state of Orissa, therefore at best the said goods can be considered that it has been brought from outside the state for use in the was contract. So only that can be used in the was contract, but after execution of was contract, there is a transfer of property. So till the execution of was, because here the contractor has brought the goods to the site of execution, and only after execution of the contract, the goods have been transferred to the contractor. Therefore, this can be an interstate purchase, but this cannot be an interstate sale. So after the goods have been assembled, a works contract has been executed because it is a civil contract, and after execution of the contract, only the goods can be sold, the transfer of property can be held. So it can be only interstate sale, Your Lordship. Now, Your Lordship, another fact, those cannot be said to have been sold, Your Lordship. Now, Your Lordship may kindly turn to the assessment order. If the assessing officer has examined all the page 19, Your Lordship, the facts are at page 18 and page 19, the assessment order. Examination of the books of account produced in response to notice issued under section 12(4) of the OST Act reveals that the dealer has not paid any tax under OST Act with the plea that his transactions do not come under the purview of the OST Act, as almost all the supplies are from the state of Bihar against C form to Epitata sponge so and so. As well, no tax is payable or designing and engineering charges or erection and commissioning charges. I've analyzed the detail of the agreement executed by the dealer with Epitata Sponge Iron and perusal of the later number so and so Tata Iron and Steel, who placed order with the dealer on behalf of Epitata. It is revealed that contract covers designing, engineering, manufacture, supply, delivery at site, erection, commission of equipment and facilities, including electrical items and accessories for the so and so handling system for the Tata Sponge Iron plant. But also, as per the clarification of Tata Sponge Iron Limited on behalf of the Epitata Sponge Iron, besides, it is also noted that the total price of the design so and so material handling system inclusive of transit and site insurance, but inclusive of taxes, duties and other levies of rupees so and so. On the basis of the conditions stated above, it can safely be concluded that contract executed by the dealer Epitata is an indivisible contract, and hence this transaction come under the purview of the definition of 2JJ of the OST Act. The dealer has executed the alleged work on 85-87. On perusal of the accounts of the dealer, it is revealed that the dealer raised bills for rupees so and so Epitata during the period so and so according to the GTO. So therefore, my respectful submission before Your Lordship, because it is a peculiar contract, and since the after execution only the goods, the transfer of property has been made, so it is only can be Interstate sale. It is not disputed that it is interstate purchase for use in the wash contract. And after use, the goods have been transferred, the property has been transferred.
You're not impressed, sir. These are all factual determinations. I'll write a letter order. The revision petition is dismissed.
Special week list item number 11.
Let's see, item number 11, 12, 13, 14. These 4 cases, files are not, because the parties are, this is Paradip Port Trust and Mukund
Files are
Iron.
not
So
traceable.
let's see, can it be taken up in some other
No,
day?
no.
I can-
Files are not traceable. Same order, sir. With permission, dismiss for non-prosecution, permission to revive the cases as and when the files are traced.
Because today is Monday, so I could not take
That's
the
all.
brief.
You're not waiting endlessly, sir. Sorry.
Let's see, the question of law may be.
Yeah. No, if you're dismissing it, then we'll leave the question of open. We're giving you liberty to revive it, then we know.
Definitely.
Special week list item number 12.
No, up to 14, he says. He's misplaced all files up to 14.
Special week item 15.
Memo is taken on record. No instructions, dismissal notice.
Special week list item number 16.
16, my lord, I am praying for Passover on behalf of Mr.
All right.
Special week list item number 17.
None appears to.
17, I am for the opposite part number 16.
All.
Special week list item number 18.
I am for the opposite part number 9, my lord, item 17.
All right. 18, dismissal non-prosecution.
Special week list item number 19.
None appears, dismissal non-prosecution.
Special week list item number 20.
None appears, dismissal non-prosecution.
Special week list item number 21.
Mallards, I pray for 10 days time in this matter. I need to contact, the phone number which was available is no longer working. I've already given a registered letter. Lordship may grant me 10 days time, Mallards.
What is the matter about?
Mallards, this is an OEA proceeding. In the OEA proceeding, the petitioner's name was initially recorded. Thereafter, the petitioner's father's name was initially recorded. Thereafter, my lords, in a claim case, and the appeals that were filed by the Mahant of the Mutt and other co-villagers, that those were not prosecuted, they were dismissed. Thereafter, in 1889, the administrator of the Jagannath temple, he filed a claim case before the Tehsildar. Now, without inviting any objection from any quarter and without looking into the orders in the claim case, in which orders were passed in favor of the petitioner, that claim case was allowed in favor of the administrator. Thereafter, my lords, in 1993,
there's no interim order here, Mr. Mukherjee, and the petitioner was 71 years when you filed it in 2011.
That is exactly the reason why I wanted to verify what is the status, my lords.
All right, at the request of
My
Mr.
lord,
Mukherjee.
my lord, I'm for opposite party.
Yes.
My lord, the case is actually covered by the Siddhamata decision.
No, it is not. It is not. Those are Amrutamani properties. These are not Amrutamani properties.
Because my lord, OEA Act is not applicable to the DT of lands with the DT of Sri Jagannath Mahaprabhu.
No, that is a misconceived submission, my lords. I will satisfy your lordship. Those OEA case will not apply. Not apply to properties which are Amrut Manahi. These are not Amrut Manahi properties. Yeah, the properties, the petitioner was found to be in possession of the property on the basis of the OLR proceeding, and they are separate. The classification of these lands is separate. I will satisfy your lordship. Your lordship grant. I also need to properly assist your lordship with that matter.
Listed 9th May.
Oblige.
Special week list item number 22.
I am for open number 2, 3, and 4.
All right, none appears to.
I am for the petitioner.
I am for the opposite party number 1.
Please remove your mask, sir.
There is some development that the petition has been dismissed from service on 13/9/2021.
Kindly remove your mask, sir.
Sorry.
And please speak into the mic.
The petitioner has been dismissed. I am for opposite party. In the meantime, some
So
development.
let the petitioner speak, sir, if you do not mind. He is appearing for the petitioner.
I am for the opposite party. Only one information that the petitioner has been dismissed from service on 13/9/21.
Oh, that is there. I don't dispute that, and we have challenged the appeal. Appeal is pending. Here, I'm selling the order dated 13/8/2010 under Annex 6, where there was a reference on 17/11/2005 by the central government. Reference of dispute was. I'll take your lordship page 9. Whether the action of management of Dhenkanal Gramya Bank in fixing the cutoff date arbitrarily with effect on 31/12/89 for the post of field officer supervisor.
So does this dispute still survive?
Dispute
You are not
survive.
even in service now. How does this dispute survive?
Because
Whenever you come back into service, this will survive, correct?
Yes.
So
yes,
let you come back in service and then revive this petition. Right now it is infructuous, sir.
That opportunity can be given to me.
Yeah.
I'll
You say
raise
that
that
it appears that during the pendency of the present petition, the petitioner has been dismissed from service. And he has challenged that in separate
Before the appeal.
Whatever, sir, he has challenged that in separate proceedings. In that view of the matter, the present petition is dismissed as having been rendered infructuous at this stage. Liberty is granted to the petitioner to revive this petition in the event he succeeds in being reinstated in service. All right.
Okay. Special legal list item number 23.
23, my lord, I am for the opposite party.
All right. None appears. This was not possible.
Special legal list item number 24.
None appears. This is not possible.
We are for the opposite party number 1, my lord.
All right. Matter has become infructuous. 24. All right.
Special legal list item number 25.
None appears. This was not possible.
Special legal list item number 26.
May I please, your lords? My lord, here the petitioner who was working as a junior stenographer in the office of the State Election Commission had filed the writ application with a prayer that his promotion to the post of a senior stenographer be given with effect from 8/8/2011. That is the date when the post of junior stenographer was upgraded to the post of senior stenographer. But when the case of the petitioner was not considered, he had approached this honorable court in this writ application. But in the meantime, he has already been given promotion to the post of senior stenographer. But
Yes.
that promotion has been given to him with effect from the year 2016, my lord. Exact
Right.
date I have not with me, but it is from the year 2016. So, my lord, in view of that matter, may I pray, my lord, the petitioner may approach the appropriate authorities to antedate his promotion.
During the
because
pendency of the present petition, the petitioner has already been promoted as senior stenographer from 2016.
Yes.
Counsel the petitioner accordingly prays that he would like to approach the authorities for antedating his promotion. Granting the petitioner such liberty, the petition is disposed of.
Special legal list item number 27.
None appears. This is not possible.
Special legal list item number 28.
Permit to withdraw to liberty to file case if it
Liberty and all knows questions, sir. Counsel for the petitioner seeks leave to withdraw the present petitions. Dismisses.
Special legal list item number 29.
None appears. Dismissed. No.
Special legal list item number 30.
My lord, Mr. Sangnere is not well.
No, you tell us what it is about.
My lord,
kindly tell us what the matter is about.
My lord, in this case, petitioner purchased a land in 2010. In 2011, opposite party issue notice for acquire the land. That is for a company. Opposite party 3 issue notice for acquire the land for opposite party number 4. That is a private limited company. Here, private limited company.
So was there any interim order passed here?
Yes, my lord.
Status quo.
My lord.
Who's for the other side? Has notice been served?
It's opposite party number 3 I'm appearing.
Huh.
Yes, on behalf of Mr. S.P. Mishra.
What is the position, sir?
Yes, I have sought for information. If your lordship passes over to after lunch, I can provide the information.
All right, pass over.
My lord, maybe 1 week, my lord.
Pass over, sir, pass over.
Special liquidity item 31.
None appears. This is not possible.
Special liquidity item number 32.
Item 32, pray for after lunch on behalf of Mr. H.M. Dhar.
All right.
Special liquidity item number 33.
You don't know about after lunch, sir. We're just passing it over. We're just passing it over. It might come up even before lunch. Right.
Special liquidity item number 33.
This has been filed by the state. Lordship, by the order dated 9th of December 2021, the impugned order was stayed. At the time of filing the writ petition in the year 2011, the applicant was aged about 51 years.
In between, my lord, I am appearing for the opposite party. In between, he has the benefits under the tribunal's order has been extended to him.
Oh.
And he is retired also.
Then we leave the question of law open. Mr. Rajit Roy, appearing for the opposite party, informs the court that the benefits under the impugned judgment of the tribunal were extended to the opposite party, and he is also superannuated. In that view of the matter, leaving the questions of law urged by the petitioner open for consideration in some other appropriate case, the present petition is disposed of.
Special weekly list item number 34.
None appears. Dismissal not possible.
Special weekly list item number 35.
In this case, I am for the OP number 2 years.
None appears for the petition. Dismissal not possible.
I'm for OP 4, my lord.
All right.
Special weekly list item number 36.
I am for opposite party number 1.
All right.
It has become infructuous.
None appears. Counsel of the opposite party informs the court that in any event, the petition has been rendered infructuous. It is dismissed as such.
Special weekly list item number 37.
None appears. Dismissal not possible.
Special weekly list item number 38.
Lord, 38, I am for the OP number 9, my lord. Aditya Das for OP number 9, my lord. This is a public interest litigation wherein, my lord, I as an IPS officer was blemished, my lord, and which resulted in my transfer.
Anyway, you're not
So
for the
during-
petitioner, correct?
I am for the OP number 9, my lord.
All right. None appears for the petitioner.
For the
Dismissal
petitioner.
non prosecution.
Actually, this case has become infructuous.
All right. You're for the petitioner.
Yeah. Yes, your lordship.
Counsel of the petitioner states that the petition has been rendered infructuous. It is disposed of.
My lord, I have only one humble prayer, my lord. Let the allegations not be treated as a blemish on my career, my lord, because this resulted in my transfer. That's my
Once
only
it is
humble.
dismissed, so we just say it's dismissed. It's infructuous. All right.
I'm obliged. Obliged.
Okay. Special weekly list item number 39.
I am challenging the cancellation of lease. I am the original purchaser from original lessee. That is the resumption order. I am challenging under section 3B of OGLS Act. The same order has been passed to remand the same to the Tahsildar.
Who's on the other side?
Lord Mr. Katkia, Lord Appeal.
Yes, Mr. Katkia, is he there? We'll pass it over. You ask him to be there.
Special weekly list item number 40.
My lord, in this matter, the assessment order is under challenge. I may be permitted to file an appeal.
Counsel to petitioner seek to withdraw this present petition.
My lord,
Refer to
delay
file
may
an
also
appeal
be condoned.
in accordance with law. If such appeal is filed not later than 16 May 2022, accompanied by an application for condonation of delay, explaining the delay on account of the pendency of the present petition, to be considered in merits by the appellate authority. The court clarifies it has not expressed any view in the matter.
My lord,
Original
originals
annexures
may
be
be
returned,
yes.
subject to substitution with attested photocopies thereof, the interim order of status quo. What was the order? Interim order? Was there an interim order?
No, my lord, I don't.
There's no interim order. Please forget that. The petition is disposed of there.
Thank you.
I beg your
Obliged,
pardon. I beg your pardon, my lord. It's in item 37, no instructions.
37 is a no instructions.
Liberty may be given to file a fresh.
No, these are all old matters.
Lordship, please.
Special legal list item number 41.
Obliged.
None appears dismissed, not prosecuted.
Special legal list for orders item number 42.
Is not pressed, because this matter has become infructuous.
Dismissed is not pressed. All right, sir.
Special legal list passed over matter item number 16.
What it?
We are unable to connect Mr. Kotke, my lord. Lord, Mr. Kotke is unable to connect through it. There is some technical
So
error.
what we'll do is we're going to take up in the other
The old court,
old
heritage building.
after lunch.
Yes.
No, there's one more Passover. All right, we'll take it up.
Okay.
Pass over. Special weekly list passed over matter item number 16.
Very sorry, once I got
No, that's okay. That's okay. I think the AC is on. You can switch off the fans.
Since long.
Yeah, you can use the mic.
Pending.
You can use the mic, Mr. Kumar. Just switch it on. Is it on?
Plus one substitution application is pending. To substitute the legal heirs of OP number 2 since 2011. That is miscase number 3403 by 2011.
All right. You say that substitution application is allowed. Who has passed away?
Plus OP number 2 plus.
You mean the LR of OP number 2 because he was
Yes,
already impleted as late. Must be the LR of OP number 2 then.
Yes, boss.
Yes, tell us.
Notice has to go on this.
Not necessary. We'll allowing it anyway, but what is the matter about you? Tell us. There is no stay.
Plus, I am looking to come to Annexure 11. There was order process at page 80, which is under challenge. Plus, there the opposite party, the government is directed to pay rupees 91,58,634. Plus, individual amounts to be paid to the petitioners there. Plus, that has been there since from page number 79 to 80. So in total, plus 91,58,000.
This is a 33C2 application that has been allowed. Correct?
Well.
So what is your ground of a challenge?
Plus ground is there is a judgment of the Honorable Apex Court that is available at page 64. That's not from page 64. You'll also come to ordering portion at page 71. Sorry, plus page 74. Therefore, all the reasons stated above, the appeals are allowed and the orders of the High Court are set aside insofar as the pay equal to that of the regular employed staff has been ordered to be given to the NMR daily wages casual workers as indicated above, to which they will not be eligible or entitled till they are regularized and taken as the permanent members of the establishment for the period prior to such permanent status plus regularization. They would be entitled to be paid only at the rate of minimum wages prescribed or notified. If it is more than what they are being paid as ordered by this court in Jasper Singh's case, supra. But here in this case, you'll also find that the Narayan Tribunal, presiding officer Labour Court, while dealing with an application of 33C, I am coming to space 79. Basing upon the sole testimony of PW1, the direction has been passed. So the oral testimony of PW1 coupled with the claim sheet of all the petitioners appears to be true and correct regarding their entitlement. And the claim sheet filed by the petitioners so that their individual names have been written and against them what amount they are entitled to get, those have been mentioned. And at last ordering portion was the whole amount, the total amount of 91 lakhs has been paid.
So what is the ground of attack? I'm not able to understand. What is your ground of challenge?
Because it goes against plus the order of the Honorable Apex Court. That is plus passed in civil appeal number 7342 of 1993. That is the only basis clause.
No, I'm not still able to understand. What is the basis of because this is as an outcome of the High Court's order in 871 of 1991. Just come to page 78 top.
That is not the outcome, Manoj.
No, just come to the top of page 78. In fact, start with para 2 itself. Bottom of page 77.
Pardon. 78. Okay, Mile. Paragraph 3 plus.
2. Bottom of page 77. Para 2.
Yes, please. The case of the petitioner is that they were working as NMRs, workers under the OPs from 1977 onwards to till date without any break or interruption and discharging duties as skilled laborers. Due to non-regulation of their service, the employees Union of Upper Kolab NMR Workers Powerhouse Branch moved to the Honorable High Court in OJC number 871 of 1981, in which the Honorable High Court disposed of the writ application with other writs with the direction that NMRs having completed 2 years of continuous service or more may perhaps claim the benefits made available to work-charge workers in this regard. That the applicants of OJC number 871 by 1991 and TA number 47 by 1993 are working in the same establishment, then time of duty and place of duty is same and authority are same and their names appear in the same common senior list prepared by the authority of Upper Kola project. It is further plea of the petitioner that the OPs may be directed to pay the differential amounts as claimed in Form T3. Accordingly, the petitioner along with others have filed their claim sheet praying to get their differential amount from the OPs.
So
on the other hand, the OP number 1.
So they're only claiming the differential amount.
Yes, different.
How? What is wrong with the order? You're not still telling us that.
It is only differential amount.
What? Oh. Wrong. Why should this order be set aside?
That is because in view of the Supreme Court judgment, of course, I went through that judgment. That also, last portion also said like that.
You say the challenge in the present petition is to an award dated 7th April 2010, order dated 7th April 2010, passed by the Labour Court, Jaipur at Koraput in industrial dispute miss case number 37 of 2008, filed by the opposite party workmen. Paragraph. The aforementioned case was filed by 48 workmen, by 49 workmen under section 33 capital C bracket 2 of the Industrial Disputes Act 1947, ID Act, claiming an aggregate sum of rupees 91,58,634, being the differential wages that they were entitled to, having worked from 1977 onwards as skilled laborers. Full stop. Earlier, the said workmen had approached this court along with certain other workmen in OJC number 871 of 1991, where a direction was issued that non-muster roll workers, bracket NMRs, having completed 2 years of continuous service or more, could claim benefits made available to work charge workers. Full stop. Paragraph. It is on that above. It's on the above basis, where the facts were not disputed, of the petition of the workmen having completed more than 2 years of continuous service, that the Labour Court proceeded to allow their claims and issue directions for payment of the differential wages as per the calculation sheet filed by the workmen. Paragraph. It requires to be noted that this writ petition was filed on 28 February 2011, but kept in defects throughout. Full stop. As a result, not even formal notice has been issued in the present petition till date. Full stop. Meanwhile, some of the workmen have died and their LRs have been brought on record. Today, another application was filed which is allowed, bringing certain LRs of the LRs on record. Paragraph. Having heard learned counsel for the petitioner and having perused the impugned order of the Labour Court, the court finds no ground made out for interference. Full stop. even the judgment of the Supreme Court dated which is that page where the Supreme Court judgment you read? Even the judgment dated 29th October 2002 of the Supreme Court in civil appeal number 7342 of 1993, State of Orissa versus Balaram.
Date is 29th October 2002.
Yeah. Balaram Sahu and others. Only reiterates the well-settled principle that NMR/daily wages will be entitled to regular wages after they become regularized, and prior that would be entitled only to minimum wages. Full stop. The court does not find anything in the impugned order of the Labour Court which can be said to be contrary to the above judgment of the Supreme Court. For all of the aforementioned reasons, the court finds no ground to interfere. The petition is dismissed.
Special weekly list, pastor matter, item number 30.
On item 30, I am appearing for the ITCO matter.
Yes.
For OP number 3, actually the land acquisition process was started by the government. OP number 1 and 2, 4-1 notification was issued. And
who's for the petitioner, sir?
I don't know.
Item 30.
I am for petitioner. I am for petitioner, my lord.
Tell us, what is the matter about?
My lord, opposite party number 3 and 4 is joint venture. 4 is a private limited company for set up a hotel. Issued notice by the opposite party number 2 to the petitioner to acquisition of land. Here,
So there is no stay order passed by this court. What has happened in the meanwhile? Is there any stay order?
Yes, my lord.
What has happened, Mr. Mishra? Can you tell us? There is a status quo order, he says.
We have deposited the money as per the direction of the government.
No, this is a stay continuing since 18/10/2011.
But this stay means his status quo is there. No stay.
No, what was the stage of the proceedings?
Proceedings the government can say, well, government was initiating the proceeding.
So I filed a contract.
What's the date of the Section 4 notification, Section 6 declaration?
Page 49, my lord. 18/1/2011.
That is Section 4.
Section 4(1).
So it did not go to the stage of Section 6?
Yes, my lord. It has been done further. They can give the record, my lord. They have got the record. Government has got the record.
No, but no award was passed.
But I deposited the money as per the instructions received today. Unless the award is passed, I cannot deposit the money. Money has been deposited.
Well, I'll also peruse the counter affidavit filed by OP number 2. This, I am reading the relevant portion. From the notices under Section 9(1) were issued by the LA Collector Bhadrak, fixing date to 21st October 2011 for finalization of award under Section 11 of the Land Acquisition Act. But the Honorable High Court passed an interim order of status quo on 18/10/2011 regarding position of the land. And the award under Section 11 of the Land Acquisition Act could not be finalized on 21st.
So no award has been passed as yet.
That's not good.
Who is appearing for the private company? Anyone appearing for the? So none of you has moved to vacate the stay also.
Yes.
So obviously you're not interested in the land anymore. Mr. Mishra, this was at the stage when the award had not been passed.
But I was told that the money has been deposited, in fact.
That was deposited a long time ago with you.
Yes, my lord.
No, the possession is still with these petitioners.
Status quo is there, therefore the possession was not have been disturbed, my lord.
That is the reason. Status quo is the reason.
No, status quo means possession was not taken, correct?
No, I think government has not taken possession.
So then what would be the value of land now?
But
Much higher.
if they actually initiate the proceeding, I think the new act will be applicable, my lord.
Correct. The award has not been passed, so the proceedings lapse. They'll have to start the proceedings afresh.
If fresh cause of action arises, government has to initiate the proceeding, my lord.
Correct.
No, absolutely. 11A period shall be which an award within made.
No award was made, sir.
Lapse loss.
It has lapsed. Yes. You say the status quo order was passed by the court in these proceedings on 18th October 2011 at a stage when the award under section 11 of the Land Acquisition Act 1894 (LA Act) had not been passed. Paragraph. That status quo has continued since. Full stop. Now with the enactment of the Right to Fair Compensation and Transparency Land Acquisition Rehabilitation Resettlement Act 2013, the proceedings under the LA Act 1894 have obviously lapsed, particularly since, on account of the status quo order, neither was the award passed nor possession taken of the land in question. Paragraph. In that view of the matter, the state government will have to start afresh proceedings under the 2013 Act, which will obviously give to rise to a fresh cause of action. The present petitions accordingly disposed of as having been rendered infructuous.
Special weekly list pastoral matter item number.
You say as regards the amount deposited by opposite party number 4 with the IDCO, it will be open to them to apply to IDCO for its refund forthwith, with whatever interest may have been accrued thereon.
Now, IDCO is to get the money. IDCO is to get it. They have deposited.
I know, but you'll have to return it to them now.
No, IDCO is to get the money. Nobody has deposited with me.
Get which money?
Yes, IDCO actually has got a fund to.
Oh, so IDCO had deposited with the state?
Yes. Yes.
Oh, I see. So you say IDCO can apply to the government to get return of the monies with whatever interest may have accrued thereon. Okay.
Item 32.
Item 31 for opposite parties. Yes.
May I please? But the petitioner challenges the order under Annexure 6 at page 29. Annexure 6, page 29, by which the lease in respect of the additional plot that was granted by IDCO has been cancelled, madam. But petitioner was in an industry which was established in the year 1983, madam, and that was allotted a plot by IDCO bearing plot number S-3/86 for establishment of an industry, madam. And I was carrying on my activities, madam. With the growth of the activities, madam, I wanted an additional plot. In the meantime, the additional plot was available, and which was allotted to another industry, and by virtue of the order under Annexure 2, my lord, at page 11, my lord, the IDCO agreed in principle to transfer the land in my favor, for which a tripartite lease deed was also executed under Annexure 3, my lord.
What were you to use the land for?
My lord?
What were you to use the land for? What was the use to which you had to put the land?
Expansion of my industrial activities, my lord.
So you never put it to that use? My lord, you started using it for parking. That's what the impugn notice says.
No, my lord. On 2 reasons they have cancelled, my lord. I was issued the so-called notice under Annexure 4 at page 26, saying that I have violated clause 7 of Annexure 2, my lord. Clause 7 that they have quoted at page 26, lord, you may kindly see, as per clause 7 of the transfer letter, you have to start industrial activities in the premises within 17/7/2006. Since the transfer of the unit, the property is lying vacant and no industrial activity started till date. This they say that you have violated clause 7. But the annexure 4 reads that you have not established, kindly say at the beginning of annexure 4. Dear sir, IDCO plot number 57 and 58 measuring an area of such and such industrial Manchester has been transferred in your favor by transfer letter dated 993 dated 18/1/2006, that is annexure 2, for establishment of hydraulic and pneumatic grinder and piston general coupling power plant spare unit. So they have issued the so-called notice in the precincts that I am to establish an industry matter. Whereas the clause 7, which states that I am to start my industrial activities matter. Now, my lord, in any event, in reply to the so-called notice, I have filed my reply under annexure 5 at page 27, my lord. This reply was sent to them at page 28, lords may kindly see, sent to them by registered post as well as by courier service. The Xerox I have also pasted in the so-called reply matter at page 28 matter. Now they cancel the lease under annexure 6 at page 29 on the reasoning that you have not filed your reply to the so-called notice. In paragraph 12 matter of the writ application I have averred, paragraph 12 will also kindly see page 5. That the petitioner respect to submit at the impugn order cancelling the lease oblique allotment in respect of IDCO plot number 57 and 58 is absolutely illegal, arbitrary, and has occasioned to total non-application mind in the impugn order. In the impugn order stated that petitioner has not submitted his reply to the so-called notice, which is clearly an error of record. As a matter of fact, the petitioner submitted his reply to the so-called notice under annexure 5, and the said reply there has been a reference to the so-called notice under annexure 4. The reply was sent by registered post as well as by courier services, and the counter they have filed, they have not refuted this one.
Anyway, that's not even the main point. The main point is not putting the land to use.
My on 2 reasonings they have cancelled. That I have not submitted my reply and I have not established the industry matter.
What is your reply to the second part?
That I have said, madam, towards last of page 27. Old equipments of many factories returned for repair are also kept there. We require further space of little more than 1 acre because of the little space still available with us. It is not sufficient for completing the orders of various industries in time. We have already cleared all IDCO dues of the above plot and will continue to coordinate our site activities from plot number 57 and 58, including repair, maintenance, and replacement of.
There is no reply at all, sir. This is no reply. You are only saying why you need additional land. You are not answering why you have not used the land so far.
The clause 7 says I am to undertake industrial activities.
What activity have you undertaken? You have not undertaken any activity.
But their cancellation was on the basis not that I have not established the industry matter.
That's right. On the additional land, you have to commence some industrial activity on the additional land.
And in any event, matter, they have not considered my so-called reply matter.
What is the point? You haven't answered the main point. You have not answered the main point.
And there is no, they have not refuted.
Even today, have you set up, are you using that extra land for anything at all?
To that part, my lord, I'll take instruction.
No. We're not adjourning.
But no, I'm not seeking any adjournment since your lordship wanted a query, my lord. That's for since your lordship wanted to know within this time whether any activity has been undertaken in the meantime. For that, I wanted that Lordship may grant some time so that I can take
Is
instruction.
that not an adjournment?
No. But my lord, my submission is that non-consideration of the so-called reply.
Sir, if that reply contains something substantial, where you have given a proper explanation for not utilizing the land, I can understand. There is no proper explanation in that reply at all. So it will become an empty formality if you simply say consider his reply. And that too in 2022.
Sir, he has rather admitted that they have not made any construction. If you
That's what.
see para one of the reply, they have made it clear indirectly that no, we have not made any construction.
Yes. All right. The challenge in the present petition is to an order passed by the Orissa Industrial Infrastructure Development Corporation (IDCO), cancelling the allotment of plots 57 and 58 at the industrial estate in Mancheshwar, Bhubaneswar, and requiring the petitioner to hand over the possession of the said plots to IDCO within 15 days. While directing notice to issue in the present petition on 14 November 2011, this court stayed the operation of the said impugned order. That interim order has continued since. Paragraph. The background facts are that the petitioner is a proprietary concern engaged in the manufacture of boilers and boiler parts, heat exchangers, and so on. Full stop. It was stated to have been established in the year 1983 and undertook its activities at plot S-3 by 86. Full stop. According to the petitioner, its workload increased, and in order to expand its activities, it required an additional plot of land. Full stop. Messrs. Lord's Steelex, which had been allotted plots 57 and 58 in Zone D, Sector A of Mancheshwar Industrial Estate, became sick and agreed to transfer the plot allotted to it in favor of the petitioner. Full stop. Accordingly, the petitioner approached IDCO full stop. On 18 January 2006, IDCO wrote to Lord Steelex agreeing in principle to the transfer of leasehold rights in respect to the above plots in favor of the petitioner. Stop. On 4th February 2006, IDCO wrote to the petitioner asking it to execute the necessary tripartite lease deed. Full stop. One of the conditions on which the above plots were allotted in the above manner were transferred in the above manner in favor of the petitioner was that the petitioner had to commence industrial activity within the said premises within 6 months from 18 January 2006. Full stop. With the petitioner not commencing such activity, even for a period of 4 years thereafter. ITCO issued a notice on 4th November 2010 to the petitioner asking it to show cause why the allotment should not be cancelled. Paragraph, the petitioner claims to have replied to the said show cause notice on 17th November 2010, a fact which is denied by ITCO in its counter affidavit. Stop. In fact, ITCO passed the impugned order dated 24/10/2011 on 2 grounds. Stop. One was that the petitioner had not replied to the show cause notice. And the second was that it had failed to commence industrial activity, failed to utilize the allotted plot for which it was transferred, and the land was lying vacant and open quotation partially used for vehicle parking, unquote. While the petitioner assails the impugned order on the ground that it had in fact filed a reply to the show cause notice, as regards the main ground of cancellation, the petitioner states that it had, open quotation, undertaken maintenance and job work at site on hydraulic and pneumatic cylinders and pistons, etc., unquote. However, the counter affidavit, ITCO maintains that the plot in question has not been put to use by the petitioner in terms of the conditional allotment made to it. Paragraph. Learned counsel, the petitioner submitted that since the petitioner had in fact filed a reply to the show cause notice, one of the grounds of cancellation was not valid. However, counsel, the petitioner was unable to inform the court whether even today the plot has been used for the industrial activity for which it was allotted to the petitioner. In the absence of any rejoinder affidavit to the counter affidavit filed by ITCO, it appears that petitioner was unable to use the land allotted to it within the time period stipulated. In other words, plots 57 and 58 continue to remain unutilized, as has been stated in the counter affidavit of ITCO. In the circumstances, sending the matter back to ITCO only to consider the reply of the petitioner would serve no purpose. Full stop. The main reason for cancellation therefore appears valid and calls for no interference. Paragraph, for the aforementioned reasons, the court finds no grounds made out for interference with the impugned order dated 24th October 2011, passed by ITCO. The interim order is vacated, this petition is dismissed.
Pastoral matter item 39.
Cancellation of lease matter. I am the purchaser from the original leasing. This Honorable Court has remanded the matter.
So what's your on 18/6/1998? The land has been resumed.
No, he says he's the bona fide purchaser. What was the date of your purchase?
It is on 91, 27/9/91. 91.
So this resumption was after the purchase. You say the petitioner is the purchaser of leasehold land.
The original lessee is not a party. Because the original lessee was a Javan in favor of whom 5 acres of land was allotted. He has not been made a party in this case.
Whose lease has been cancelled by the impugned order dated 18th January 1998 of the Tahsildar Bhubaneswar in WL case number 349 of 1985. In fact, the petitioner purchased the land much prior to the impugned order in 1991 itself. Clearly, therefore, the petitioner ought to have been heard before the impugned order was passed. Paragraph, Mr. Katkia, learned counsel appearing for the opposite parties, points out to that the original lessee has not been made a party in these proceedings.
No, what party? Opposite party not 5.
No.
Yes.
1, 2, 3, 4.
Yes,
No.
I have filed
Gopal Krishna Day, it's there.
Yes.
All right, just take that out. On the above short ground, the impugned order dated 18 June 1998 of the Tahsildar Bhubaneswar is set aside, and WL case number 349 of 1985 is restored to the file of the Tahsildar Bhubaneswar for being proceeded with in accordance with law. The petitioner will appear before the Tahsildar Bhubaneswar along with a certified copy of this order on 9th May 2022. Full stop. After hearing the petitioner and the original lessee and any other party who may be interested in the land in question, a fresh order will be passed by the Tahsildar Bhubaneswar within a period of 4 months thereafter. Till such time, the status quo order passed on 16th April 2012 by this court in the present petition will continue. The petition is disposed of in the above terms.
Weekly list, fresh admission, item number 1.
Item number 1, on behalf of Mr. Kekerao, no instruction. No instructions disposed of.
Weekly list, item number 2.
And identical matters, my lord. Earlier, this court asked such of orders matter.
Three.
All right, same order.
Weekly list, item number 3.
None appears dismissed non prosecution.
Weekly list, item number 4. Weekly list, item number 4.
Oral has become infructuous.
None appears. Counsel for the opposite parties, the learned AG states that the petition has been rendered infructuous. Dismissed as such.
Weekly list, item number 5.
Permitted to file liberty, lordship can give liberty file better application.
Counsel for the petitioner seeks leave to withdraw this petition with liberty to file a better petition in accordance with law. This petition was withdrawn with liberty straightforward.
I am for the opposite.
All right.
Weekly list, item number 6.
In this petition, my lord, the petition challenge the inaction of the opposite party, my lord. Only any inquiry, my lord, that the land, government land has been settled in favor of the private individual, those who are not belong to same locality, my lord.
Representation. Has his representation been served?
My lord?
Where is the proof of submission of representation? Where is that?
Yes, there I have filed a declaration, my lord.
No. Where is the proof of? Okay, that received stamp is there. All right.
There is receipt stamp is there.
The petitioner's representation dated 18/9/2020 shall be examined by the Revenue Divisional Commissioner (RDC) Northern Division Sambalpur, and after issuing notice to the petitioner as well as opposite party number, you not made that who it has been allotted parties at all.
The private individual I have not met.
Why not?
Then lordship permit me, I'll file.
No.
Substitution.
Have you mentioned the private individual in the representation?
No, that representation also nowhere disclose the name of the.
Make a fresh representation, sir. Counsel the petitioner seeks leave to withdraw the present petition.
I have given the name in my writ petition. I have mentioned my name. Lordship permit me, I'll file.
No, you have to.
In the representation.
Oh no, he has mentioned Tahalu Sahu.
My lord, in paragraph 6, my lord, I have given my lord.
So only one Tahalu Sahu.
Paragraph 5, I have also mentioned my lord.
No, no.
Tahalu Sahu, my lord. Tahalu Sahu, and another is Premlata Gupta. That is Kishore Kumar Naik.
No, no, no. You only mentioned Tahalu Sahu, sir. Come
In
to
the
page 31. You mentioned only Tahalu Sahu. I think you make a fresh representation. You say, counsel to petitioner seeks leave to withdraw the present petition with liberty to make a fresh representation to the authorities, properly naming the persons in whose favor the allotment was made and to which the petitioners have objection. Drawn in the above.
Mashman, item 7, the virus of criteria 2004 is under challenge, Your Lordship. Similar matter has been posted to 7th of July. So I pray, My Lordship, this matter be typed up along with WPC number 23222 of 2020, Your Lordship.
23222 of 2020.
My Lordship.
List along with on 7 July.
Yes, Your Lordship.
All right.
Weekly list item number 8.
Copy be served.
Copy already served. Copy has already served.
All right.
Weekly list item 8.
All that matters are coming on 28th of June, let's see. This is regarding the challenge.
28th of
June.
List along with
The WPC number 24237 of 2019 and other.
24237 of 2019 on 28 June. All right.
Copy be served. Copy of the report.
Copy served.
Copies of the petition be served on learned AGA. All right.
Weekly list item number 9.
Similar matter has been disclosed documents regarding that Momita Meher matter, Balangir district. Lordship has,
Mr. Narsingh Mishra is on VC.
Yes, Maria.
So you will have to unmute, sir. You can ask someone to help you to unmute.
Hello, thank you.
Hi, yes, Mr. Mishra. We can hear you.
Can I please your lordships?
Yes.
This is a public interest litigation arising out of a sensational murder case of Orissa in the district of Kalahandi, which actually stunned the people of Orissa, and it was debated in public at that time and talk of the state. The deceased was Momita Meher of village Jharni in the district of Balangir. She was a young girl and was serving in an educational institution of which the accused, number 1, is the owner. She was educated in that institution. She joined as a teacher and ultimately became the principal of the institution. Now, after she became the principal of the institution, as the record shows, she developed closeness with the owner of the institution.
No, but one minute, Mr. Mishra. As we understand it, I think the accused has been arrested. And what is the stage of the present investigation? A charge sheet has been filed?
Charge sheet has been filed.
Yes, my lordship. Charge sheet has been filed in the meantime.
Yes.
And the case has been committed to the Court of Sessions.
All right. So what is your prayer today?
The prayer is for re-investigation or further investigation.
Sir, that can be undertaken by, if you want a re-investigation, you have to move under 173(8). Once the matter is seized off by the Sessions Court, sir, you can seek your remedies under the CRPC.
Since it has been committed later on or charge sheet has been filed later on.
Yes, you may want to advise, sir, you may want to advise the petitioners to seek appropriate remedies that are now available to them under the CRPC, sir.
I agree with your lordship. I may be permitted to withdraw this case.
Yes.
To take further steps in accordance with the law.
Correct, sir. Thank you. Thank you. Mr. Narsingh Mishra, Leonard, Senior Counsel, appearing for the petitioner, states that he may be permitted to withdraw the present petition with liberty to seek appropriate remedies in accordance with law. Disposed of as withdrawn with liberty is paid for. All right. Thank you, sir.
Thank you. Weekly list item number 10.
Item 10 that filed is PIL or you see that annexer 1 series page 14.
Yes.
Without taking, of course, that is in Odia, without taking recourse to the provisions of Orissa Municipal Act and rules framed thereunder. And within 24 hours, the landless and homestead persons are asked to vacate the government land. You also see the impugned notice itself is a defective one. There is no plot number, no khata number, nothing. Annexer 1 series page 14 till.
So why is no affected person joining you?
Notices are not the petitioners, madam.
No, of course, he is a public interest litigant.
Yes.
No. You are talking of residents of 3 districts, correct? 3 places, Bolangir, Titlagarh and Kantavanji.
No, Titlagarh, Kantavanji is coming under Bolangir district.
Thank you, sir. Thank you for letting me know that.
Yes, Lord.
But you could not find a single person resident in any of these places to join you in the petition.
No, I thought it will be better to file.
How is it better?
Because
where an affected person doesn't come and somebody else, you're not affected, correct?
That cannot be a public interest because if the affected person.
So why not? Why can't? We'll entertain a PIL if the others are unable to come to the court. If they're able to come to the court, why should we entertain a PIL?
I'll also see annexer 2 series also that.
Answer the question, sir.
Yes.
If the affected persons can come to the court, why should we entertain a PIL?
No, again, that will be delayed. Again, I have to.
You don't have to ask the affected people to come.
That PIL rules, they have to again notice 2 months notice, then all this.
No. It's the other way around, sir. You file a PIL when others are unable to espouse their own rights. If these people have come to you, you're a lawyer. I presume you're a lawyer.
One lawyer from Bolangir has sent me.
No. Are you a lawyer?
Yeah.
So if people have approached you, why don't you advise them appropriately that they can themselves file a petition? Why should you file a petition? PIL is meant for people who cannot themselves approach the court. That is one criteria, sir.
Most of this, I am mitigating the distress condition, mostly landless.
So you are certainly a savior for the underprivileged. All right.
Yes.
You stand up for the causes of the poor in the country.
Yes.
We will give you that certificate. There's no difficulty, sir. But when those poor and underprivileged can come to the court, you should advise them to say, I will file. Please give me the wakalatnama. Please give me instructions. I will draft a proper petition for you and you will file it in your own name. That's the correct way to assist people, sir.
Yes.
You want to do that? You can withdraw then.
And you'll also see the bio of that additional affidavit. There was a signed notice, and person in notice they have given reply. That OP number 1 has given a reply.
So let them come before the court themselves. It's all right.
As you also.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty for the affected individuals to themselves come forth with appropriate petitions before the court. Disposed of is withdrawn with liberty as paid for.
Weekly list item 11.
May I please, my lords? So I've already removed the defects, my lords. Here the case, my lord, is impugned orders annexure 4 at page 84, my lord, which is the stay order passed by the Income Tax Officer Ward 1 Bhubaneswar, annexure 4, my lords.
Yes.
A one-liner contrary to your lordship judgment and the judgment of the Honorable Supreme Court, where he just says that since the CBDT circular, my lords, says it is 20%, you pay off 20%. The last line, last three lines of
right.
page
Mechanically
40.
applying the-
Mechanically applying. Your lordship may only permit me, so far as the prima facie case of the petitioner is concerned, my lords, the petitioner, my lord, is an autonomous government college under the Department of Higher Education, my lords. So it had opened up with the permission of the government and the instructions of the government certain self-financed courses like MBA and BBA. my lords. For that, as per the government's order, my lord, it entered into a MOU with opposite party number 4, my lords. And so far as the revenue, my lord, is concerned, there was a sharing as per the government's instruction at the rate of 25%, 25-75 so far as BBA courses are concerned.
No, we'll just send you back to this.
No, what I was trying to humbly pray, my lord, my appeal is now pending before the CIT appeals, my lord. What has happened in a similar matter, so far as the BJP Autonomous College is concerned, almost in similar circumstances, the CIT appeal has given them the relief, saying, my lord, that it is no principal agent, it's a relationship exists. So 194J of the Income Tax Act, my lord, which states that fees for professional or technical services is not concerned here, my lord. Your lordship may only permit me to place one paragraph from that commissioner's order. I've also given that LG Electronics order. Also.
No, Mr. Kara, I just wanted to ask you a question. Your challenge is to an order by the ITO, is it?
ITO, my lords. And thereafter, my lords, at paragraph 7, I have said that I went to the commissioner, my lords. The commissioner refused to accept my application, my lord. Your lordship may kindly turn to page 9 at paragraph 7, my lords. He refused, my lords. That's why I was compelled to come before your lordship's, my lord, but otherwise, and attachment is imminent.
Will give you give a direction that he should accept your application and deal with it in accordance with the law.
What I was humbly praying, Lord, since the commissioner appeals in a similar situation where BJP Autonomous College was running a course, Lord.
No, but why should we pass that order? He should pass that order.
True, my lords, but I was only praying that if your lordship would stay this demand till my appeals are disposed of. Your lordship, I'll just place the appellate order, my lords. The appeal is directed against order number so and so. The appellant is aggrieved against the order of the income tax officer, that's AO, in which the appellant has been treated as an assessee in default for not deducting or depositing TDS.
No, but you should have already filed this appeal. Sorry, Lord. You should have already filed this appeal.
No, I have already filed the appeal. The appeal is pending. So I am showing, so far as a similar situation, my lord, in so far as BJP's autonomous college is concerned, where they had also opened up self-finance courses after the permission of the government and the direction of the government, my lord. The lordship may straight away come to paragraph 4.1 at page 3, my lords.
No, a revision is maintainable, but opposite party number 2 is not entertaining the revision petition.
My lords.
So we'll ask him to entertain your revision petition.
Your lordship may do that, but since this commissioner appeals in a similar situation.
No, you can point that out to opposite party number 2.
My lords. Or I was only praying that if the lordship would stay the demand.
No. If you filed an appeal before the CIT,
I have already filed an appeal.
No, you should only file an application before the same authority.
But as per 220 subsection 6, it's the assessing authority who is to stay the demand in view of the pendency of appeals before any higher authority.
I think we'll permit you to go before opposite party number 2 then.
The commission
the short prayer as far as the present petition challenging an order dated 31st March 2021 of the income tax officer, Ward TDS 1 Bhubaneswar.
It's 9/3/2022.
Is concerned is that on dated 9/3/22 is that the petitioner's revision petition against the said order should be asked to be accepted by the opposite party number 2, that is the Commissioner of Income Tax bracket TDS Bhubaneswar. Full stop. In para 7 of the present petition, it is averred that after the impugned order was passed on 9th March 2022, the petitioner did approach opposite party number 2 with a revision petition, but it was not entertained and returned to the petitioner, thereby compelling the petitioner to approach this court. Paragraph. Since a revision petition is in fact maintainable against the impugned order, the court sees no reason why opposite party number 2 is refusing to entertain the revision petition. Full stop. Consequently, a direction is issued that if the petitioner presents a revision petition again to opposite party number 2 along with a downloaded copy of this order, not later than 16th May 2022, the said revision petition will be examined on its merits by the Commissioner, by the CIT bracket TDS Bhubaneswar, and an appropriate order passed in accordance with law within a period of 10 days thereafter. Till such time, the impugned
orders by Annexure 3 series.
Yeah, the impugned orders at Annexure 3 series dated 31st March 2021 shall remain in abeyance.
I just humbly pray, my lords, maybe no, till the disposal.
Till filing of the revision.
Till the revision petition is taken up and an order is passed. Because it's anyway interlocutory nature, the whole order.
May I just humbly pray, my lord, I may be permitted to show this letter of the commissioner.
Why should you need permission for that? I'm sure you will show it. Yes.
And let him also follow LG Electronics, my lord. They are
we can't dictate to everything, every line that they should write, we can't say.
My lord, they're more obsessed with the CBDT circular than the LG Electronics.
See, if they don't do that, you'll get one more ground to come back.
Obligation.
All right.
I filed my memo. I filed my memo.
All right. Mr. Mahapatras, name leads.
Weekly list item number 12.
The village road has been encroached by some villagers. The representation on 3 series. And page 19, your lordship, see, I have also made parties to them, and also postal track that is 21, page 21, 22.
All right. The petitioner's representation dated 31st October 2021 will be examined by the Tahsildar Nowgaon. District Jagat Singhpur, bracket opposite party number 3, and after issuing notice to the petitioners and opposite parties 4/2/14, and after giving them a hearing, a reasoned order should be passed there or not later than 20th June 2022 and be communicated to the parties not later than 27 June 2022. If agreed by such order to be open to the parties to seek appropriate remedies in accordance with law, the court clarifies it has not expressed any view in the matter. The petition is disposed of.
Weekly list item number 13.
Date,
Item number 13.
None appears dismissed. Oh,
no.
Mr. Mishra, yes, tell us.
Hi, Jalan. May I please your lordships?
Yes, please.
This is a public interest litigation filed by the farmers of the district of Balangir.
Right.
Long back. Interim judgment has been passed. Also 20 years back. Now, in the meantime, I have some problem. I have been appointed as the chairman of the standing committee of Orissa Legislative Assembly relating to the department which is subject matter of this case.
Okay.
And as the chairman or as a member of that committee, I have endorsed to all the papers of that department and of the government. So I feel embraced. So with your lordship's permission, I would like to withdraw from the case and intimate the petitioners to engage some other laws.
All right. All right. Mr. Narsingh Mishra, learned senior counsel, informs the court that since he is chairperson of the standing committee of the Orissa State Legislative Assembly looking into the issues involved in these petitions, he would like to recuse and instruct the petitioners to engage another counsel. Full stop. His request is accepted and he is discharged from appearing on behalf of the petitioners.
Sir, it may be posted after summer vacation.
All right. List on 11 July, sir.
Yes, sir. Thank you.
Sir, I'm appearing for the Food Corporation of India in this matter.
All right. 11 July.
11 July.
Okay, sir.
Right.
Weekly list item number 14.
Item number 14, I don't know why it has come.
WPC number 4737 of 2003 has already been disposed of and dismissed.
Oh, I see.
My lord, this matter is the same matter where we filed a review and review has.
Yeah, the review is allowed, sir.
That was disposed of, again it was reviewed and again it is posted for hearing.
It's actually restored and therefore posted for hearing again.
And IDCO has no role to play. IDCO has themselves said that we have relinquished the land.
Yes.
Person for whom they have
But
relinquished.
so far as the other matter is concerned, 10969 of 2005.
Yes.
That is also tagged with this case.
Yes, this is tagged, but then if this is allowed, my lord, that is
In that
irrelevant
case,
because that is
IDCO
an
is the
eviction
main
case.
party. In
Because I was
2005
supposed
case.
to have been, my lord, what happened, my lord, in this case, unfortunately, the state took a plea. They initiated 4. They didn't give me notice. And in the notice, they indicated that they from 1977 onwards, that some fake RORs have been created. And a high-level committee has directed the collector at the Tahsildar to file an application before the consultation authorities. They filed the application before the consultation authorities. And then the objection was dismissed and the land was settled in my favor. And the acquisition is 1997. Till 2002, they received rent from me. And after that, they didn't. And now, my lord, I filed the review, my lord, on the ground that it was indicated as if I was not a person interested, not the owner. My lord, I filed I was able to get the order of the consultation officer where it has been, the objection of the Tahsildar has been dismissed.
And they did not file any revision?
No, they have filed it. They have filed.
We acknowledge that
and
division was dismissed.
no review.
No, but after that you have not challenged anything.
Yes,
that order is not.
that is the letter I have filed before.
Letter
your
is filed, my lord, no
letter of
review,
the
no
collector.
revision.
That's what I said.
That is the only point.
Now the case is to be heard on merit.
Merit what? This is the only merit, my lord. No notice under 9.3, no notice under 4. And if it is the land of the government, my lord, where is the question of an acquisition? All these things come in, my lord. And matter is that 9.3 notice is mandatory. 8.1 in most states, my lord, 4.1 also has been amended to give a notice. Unfortunately, our state it has not been, my lord. And even the public notice, my lord, we were unaware of. And even 5A, my lord, the objection interestingly was filed by the Tahsildar. I mean, totally unknown to the Land Acquisition Act, my lord.
How can a government land anyway be acquired?
Exactly.
No,
it's a land belonging to the government. Where's the question of acquiring it?
And then, my lord, frustration of object because IDCO themselves have surrendered it. It was given to IDCO for industrial development.
And IDCO surrendered it.
Has surrendered it.
So, Mr. Mukherjee, you're not disputing that?
No. In fact, I have already filed a affidavit. To that effect.
Yes,
I have filed an affidavit with the annexure, which is dated 9/2/2021.
Page 62. Page 62, my lord, mechanism.
Where it could relinquish the land in favor. It could to relinquish the land in favor of 2. That is 2.
The Revenue Department.
Yes, and Revenue and DM Department in turn shall alienate the land in favor of Tourism Department. So they, in fact, there is a Satsang.
It was industry, then tourism.
One Satsanko project, Mr. Mahanti is there who will apprise the court. They are trying to develop the entire corridor, and that's the reason the Tourism Department has taken over these lands. And
My lord, may I submit one thing? Just now I find that for the petitioner in our chamber it was filed. So let it be taken up next week. I will ask.
My learned friend, anyone. My lord, it hardly matters to me. I also
next week any other comment advocate.
My lord, I realized that. I rang up the senior Mr. Mahanti and told him that don't come. Once I came to know, my lord, he was appearing. I said that you have to be with me in this matter. Then, my lord, in the night,
anyway, next week
your brother is appearing, so don't come.
Now, next week, Lordship may fix any other.
All right.
My lord, I am like
Mr.
my lord,
Patkia will come and
got away from the cricket match, my lord. I am on a duty bound on 15th. By 15th, I have to complete that book of MP Jain, my lord, Constitution and Legal History. And I have no time, and my assistant is failing me. And,
No, so we'll keep it for beyond 80?
Yes. My lord may fix up any date. Early date, my lord.
No, whichever date.
Whichever date, my lord, please.
29th April, 28th April. Not 28th, sorry. 25th April.
As my lord pleases.
All right, at the request of Mr. D.K. Manti.
My lord, Mr. Kotkia's name
All right,
was
at the request of Mr. Katkia, learned AG, list on 25th April.
A council other than Mr. should get you.
That's right. All right.
Deeply obliged.
Grateful.
Weekly list item number 16.
Well, in compliance of the order dated D12/2021, today I am filing the compliance affidavit.
Where is that?
So I have filed the e-filing, but today I am filing the hard copies. Paragraph 3, my lord, may kindly sir. We have stated that during further inquiry, 161 additional structures have come out. So that now the total figure has gone up to 18,621, and out of 18,621 steps have been taken in respect of 13,282, and as far as rest 5339 is concerned, steps are on. And from December 2021 to up to the end of March.
All right. A further affidavit dated 8th April 2022 has been filed by the Chief Secretary, Government of Orissa, stating that from the date of passing of the last order on 8th December 2021 till 31st March 2022, action has been taken in respect of 139 religious structures. What is that in respect of? What does that mean? Has it been removed? Or
so there are three categories. You let me second subparagraph. So let me kindly say, remove the number is 1982.
No. Between these two dates, sir, this 139. From 812 to 31-3.
There are three category of cases. One is removal, then other is relocation, and third is regularization. So,
correct. So in these 139,
yes,
how much has been removed? How much has been regularized?
That detailed figure I don't know.
However, it is not indicated how many of these structures have been removed, relocated or regularized. Full stop. In the affidavit, considering that it is further stated that action has already been taken in respect of 13282 religious structures, of which as many as 10738 have been removed and 562 have been relocated.
No, 10738 have been regularized.
No, 10738 has been regularized, sir.
Yes, 10738.
That's what I'm saying. The same thing. You're saying the same thing. All right. 1982 have been removed. Full stop. There is a balance of 5339 regularized religious structures, in respect of which it is stated that open quotation process is going on. A further affidavit be filed before the next day. List on 22nd August.
Weekly list item number 17.
Item number 17, Lords may kindly see your Lordship's order number 14. Order number 14, dated 5/1/2022.
Yes.
One time.
For what? Whom are you appearing for?
For preparing note, offensive note.
You're not clear. I don't know. You able to hear?
17, item 17.
They're not. You're not clear. You have to speak into the mic or we're not able to hear you.
One time.
On whose behalf, please? On behalf of the petitioners?
Yes.
What is the reason?
For preparing comprehensive note.
She's appearing for Sukumar Joshi or... Are you sure you're asking in the right matter? This is 18607 of 2021.
Yes, yes, my lord.
She is. All right. At the request of counsel, the petitioner who needs time to prepare a written note of submissions. Just on 27th June.
Wish list item 18.
This is Cutter made an advertisement on 14th May 2019 for recruitment of certain number of posts, including a typist, a stenographer, all these things. Some portion that is given in Annexure 1, my lord, page 13. Page 13, reservation for special category. And in that case, there is no classification of PWD, persons with disability. Simply, junior typist post was one kept reserved, and stenographer grade 3 was also reserved without any specification, whether deep down or blind or anything else. But and I appeared at the exam. I stood first. I got the information from the RTI that I stood first, but I was denied the said appointment on the pretext that after only on 6th January 2021.
So come to para 7 of the counter affidavit.
Yes. My lord, that portion that with regard to the amendments made in paragraph 6 to 10 of the writ petition, it is only submitted that other candidates placed in the merit list have been appointed in order of merit, considering the number of vacancies advertised for different categories. As regards appointment of PWD category candidates, the district recruitment committee in its minutes of meeting dated 6/1/2021 resolved to classify the vacancy in the post of stenographer grade 3 and junior typist reserved for PWD category against a specific category of disability, that is blindness or low vision. You
are hearing impaired.
Hearing impaired. And there is no such classification in the advertisement. Subsequently, they made it.
After the result, they came up with this.
Yes, after the merit list was published.
So you filled up all the posts.
That is also not clear.
If the post is vacant, the post meant for a person with low vision is vacant, you can consider this person. Although I don't know how a hearing impaired can function as a typist.
Hello. Post is junior
stenographer. So without being able to hear, how will you function as a stenographer, sir?
Date set
No, date chart is one. You answer the question. How will you operate as a stenographer if you are hearing impaired?
Well, 35% hearing impairment.
Correct.
And I'm using that machine.
You're using a machine. All right. Then you consider it. The petitioner stated to be suffering from 35% hearing disability, and counsel for the petitioner states that she can function with the help of a hearing aid.
Yes. He's using also.
As a junior stenographer, the post which is advertised, paragraph, as it transpires, reserving the post for one post for persons with disabilities was done by the committee after the merit list was published, Full stop. It was decided to earmark the post for person with low vision, oblique blindness. Full stop. It is not known how this exercise could have been performed after the publication of the merit list. Paragraph. Mr. Mudali seeks time for instructions on whether any post is vacant as of date, and in particular whether the post vacancy earmarked for PWD has been filled up. At his request, list on May.
Weekly list item 19.
19, I pray some time to file counter.
Last opportunity is granted to the opposite parties to file a reply within 4 weeks, rejoined up to the next day. 21st July.
Weekly list item 20.
Please, my lord. My lord, in this case, the opposite party number 4 has filed his counter, and in the meantime, the opposite party number 2 and 3 have also filed their counter. My lord, may grant me some more
Rejoinder.
rejoinder.
All right. Petitioner is permitted to file a rejoinder before the next day. List on 26th July.
Obliged, ma'am.
Weekly list item number 21.
Item number 21.
I am filing the counter affidavit of the opposite party number 1.
All right.
They have adopted the counter affidavit filed by the district judge, my lord. The short point involved in this case, my lord, regarding the horizontal reservation, my lord. There are 6 vacancies on all reserve category, my lord. I mean,
All
6
the posts
positions.
have been filled up and notice has not gone to the affected person.
Not permitting me to submit. 6 for all reserve, my lord. What they have done, horizontally 3 PWD, 1 serviceman, they have occupied the 3 posts. Rest 3 were denied the appointment. My lord, as per the law, they cannot move the horizontally PWD to the your category, my lord. As per their circular of the government, they first go to SC, ST, OBC, then general, my lord. Because the general vacancy cannot be carried forwarded. They have to go for SC, then ST, then OBC, then general, my lord. If that
Anyway, sir, now that we did not want to issue notice to the private opposite party, still we knew what the factual position was. Now that all posts have been filled up, we'll issue notice to those affected parties.
My lord, I have filed, initially I could not know, my lord, the position. Then after filing counter, I know 3%
So we'll issue notice to them.
Amendment was filed here.
Correct. You say Mr. Mudali has handed over the counter affidavit of opposite party number 1 today in court. He further states that all the vacancies have been filled up. In that view of the matter, notice will now issue to opposite parties 3, 4, and 5, returnable on 22nd June.
Right.
All right.
Weekly list item 22.
I'll file recusals within a week.
That's right.
Weekly item 22.
May I also file another IA for inclusion of party?
That IA has to be allowed.
Oh, which is at IA 131. All right, 131 for the reason stated. The IA is allowed. The consolidated cost title
Everything filed by.
is taken on record. So there are only 3, or how many opposite parties are there now?
3, my lord. 3 persons were appointed. 1 Excel and 2 PW, my lord.
All right. You say opposite parties 4, 5, and 6 in terms of the amended cost title. Right.
Item 22.
May I resort? This is a PIL mirror. Here the pattern are.
So there are defects.
Defects mirror.
You just remove them, sir. Defects we removed within 1 week list thereafter.
Item number 23.
My lord, I have filed a rejoinder that has not come to the record, my lord.
All right, the rejoinder the petitioner be brought on record.
Interim order may continue, my lord.
Interim orders to continue.
My lord, there is a stay order. I request your lordship to give a short date because the construction of the Kalyan Mandap has been stayed midway.
You have not produced till today. The guidelines are directed by
And
this
that is
honorable court. How
that your lordship will
location
hear
has
the
been
merit of the
shifted
case.
from one place
But
to
so
another.
far as the construction work is concerned, it is underway. Half of there is a Kalyan Mandap for the benefit of the villagers.
All right.
Ex sarpanch of that village, due to some political difference.
5th May. 5th May.
The rejoinder copy may be served on us.
Yes, I have already served.
Weekly list item 24.
My lord, in this case, your lordship has directed the Assistant Solicitor General to take instruction why that opposite partner 3 has not put under suspension by initiating disciplinary proceeding as per the resolution of the governing body of the AIMS, my lord. Your lordship kindly come to page 42. Your lordship has directed.
Mr. Pari, you have to unmute. Is Mr. Pari appearing?
Yes, my lord. Mr. Pari appearing. Your lordship directed.
1 minute. Let us ask him. He's chatting with someone else.
He is not attentive.
Mr. Pari? Mr. Pari, please unmute. This is item 24.
Unmute. Yes.
May I audible, my lord?
Yes.
My lord, in this case, the director and deputy director both have poster lying vacant. So lordship allow some more time, my lord. Lordship director.
The officers are in the director and the assistant director. The others are remaining in charge, my lord. The director of other institution is in charge. They are coming to the institution twice in a month, my lord.
Doctors, they are in charge of this institution. They are this.
They are in charge. They are coming to us.
They are in charge.
Taking all the administrative decisions, my lord.
Day-to-day affairs of the patients only. But that's, I know that there is a problem.
They are taking administrative decisions, my lord, in every month.
I don't
Twice
know,
or more they are coming. But my information is.
All right. But in charge people usually don't take these kind of decisions. Counsel for the Mr. Pari, learned ASGI, informs the court that the post of director and assistant director, deputy director, are lying vacant, and therefore some more time is needed to report about the action taken. That is request list on 23rd June.
My lord, the early date may be fixed.
I don't know whether the post will be filled up again the same thing. So that's why. All right.
Weekly list item 25.
Yes, yes.
My lord, this matter is
Without
supplying the permission,
My lord.
School Mass Education Department had supplied the permission of syntax to water tank and police permission from governor. In their affidavit, they had supplied. Let Mr. Mahapatra
Yes, my lord. My lord, here I have got the instruction, the statue with the permission of the authority. The statue has already been established and it has been already been inaugurated.
All right. So maybe in some other.
Who is the authority? Let him say. That's your lordship's query in last occasion.
My lord.
You might not have gone through the counter.
School management committee has given a proposal, and that was your lordship will find from the subsequent documents which are filed that has been.
No, where is the permission? No, just show us the permission granted for installing the statue. You're giving us all minutes of some meeting and all that. That's not relevant.
That is a proposal only, madam.
Where is the permission granted for installing the statue?
That relevant particular document I will furnish.
When? That does not. Although in counter affidavit.
Call this Monday, next Monday.
Although counter affidavit has been filed by opposite parties 3 and 4, it is not indicated. It is not indicated whether permission was in fact granted by the authorities for installing the statue in question. Mr. Mahapatra, learned standing counsel for the Education Department, seeks some more time to produce the sanction letters along with an affidavit at his request list on 28th June, sir. 28th June.
Lord,
It's all right. Statue has already come up.
1 month time.
It's all right, sir. Let the statue be.
Long date, my lord.
It's all. It's not so long. It's not so long.
My lord, with due respect to my lord, senior my lord, but Rule 6 which he has quoted, my lord, doesn't say about any such permission.
Then you file an affidavit saying no need for any permission. Tomorrow even a film star's statue can be put up then in the school.
No rule governing in the field.
How can it be? Can't be.
Well, but in government school, my lord.
In fact, if there's no rule, you better make such a rule. Otherwise, this will all go. Anybody will have some fancy ideas and start installing anybody's statue.
Yes.
Here in this particular school institution, the land donor of the institutions.
No, but if that, Mr. Mahapatra, if that were to be a rule, then in every school, some landowner's statue will start coming up.
I completely agree with your that is the.
There has to be a rule. There has to be a rule. Somebody has to apply their minds.
Yes.
Over. Oh, good. It feels very different.